Good afternoon, everyone. Allison Schaberg here, Consolidated Planning Group. We're excited to be here today with Miriam Bedore with Reliant ABA and Christina Lesher, an attorney with the law office of Christina Lesher. And so today we are going to be talking about the 5 important legal documents that you need. We're happy to be partnering with both of these ladies. So I'd like to just go over a couple of housekeeping items. Today's webinar is being recorded. Everybody that is signed up for this is going to get a copy of the slides today with any links in them, as well as the recording. So you'll get an email following the presentation today or tomorrow. You'll get that email. Also, we can't see you or hear you. We are in webinar mode, so if you were wondering about your camera, don't. We can't see you or hear you, but we do know you're there. And we love your questions. So your questions not only help yourself, but typically help others that are on listening to this as well. So as things come up, and if you have a question, we invite you to put your questions in the chat box. I'm going to be monitoring that chat box for Christina. We're going to be getting to as many questions as we possibly can during this time. If you're on a tight schedule and you're trying to figure out timelines on this, we're going from 12 to 1, so you can kind of plan your lunch or plan your break or whatever you've got going on for today. So Consolidated Planning Group, we are a holistic special needs financial planning firm. We have over 30 years of experience, and we're nationally certified as Social Security advisors and members of the Special Needs Planning Academy. We are really an advisory or consulting firm. You can think of us as a specialist. If you go to a doctor, you have a primary care physician, but if you have a specialized thing going on, like maybe you have a cardiac problem or something like that, you might go see a specialist like a cardiologist. So there are many, many financial advisors across the U.S., about 260,000. About 125 total in the U.S. are nuanced in special needs. So we are highly specialized. And this is important to families that have a loved one with a disability, because it's so critically important that we have money in the right buckets, that we preserve our eligibility for any state or federally funded programs, talking about SSI and Medicaid and waivers and things like that. And so the reality of it is a lot of the advisors, while they're well trained and they're really great, there's a lot of great advisors all across the U.S., very, very few are nuanced at all when it relates to planning for special needs. When it comes to planning for special needs, this is a lifetime. It's not we're planning until they're 18 or 22 when they graduate from college. We serve a lot of families that are going to have kids that are going to have care needs the rest of the child's life, not just the rest of the parent's life. So careful planning really goes into play for that. The average person is going to spend 25 to 35 years in retirement. So if you're a married couple, you got 2 retirements, and a lot of kids are going to have care needs 25 to 35 years after we're gone. So it's almost like a third retirement bucket. So specialized care is really, really important. So we're really happy that you guys are here today. We really focus on protection plans, lifetime care, transition planning. We're able to help open ABLE accounts. And through these webinars, we do a lot of advocacy. We have a Consolidated Planning Group YouTube channel. If you haven't found it, find it. You can subscribe to it for free. There's over 200 webinars on special needs related topics. You can subscribe to that for free and kind of pick and choose the ones for the step that you're on in your planning process. So having said that, I would like to introduce Miriam Bedore. Miriam, could you please tell us a little bit more about yourself and Reliant ABA? We're happy to partner with you today.
Well, thank you so much for having me, Allison. My name is Miriam Majlesi Bedore. I'm a licensed professional counselor as well as a board certified behavior analyst. I'm the director here at Reliant ABA. Here at Reliant ABA, we offer ABA services to kiddos on the spectrum. We don't just service the younger kiddos. The range of our kiddos is anywhere between 2 and our oldest client is 18. We're not just a clinic base, we are hybrid. So we can't teach everything here at the clinic. We want to make sure that they're able to generalize to the home or any other settings, doctor's appointment, things like that. So we try to be there for the families however way we can, where their needs are, and meet them. Our sister company, Reliant Health Group, also offers OT, PT, speech, And they also have private duty nursing. So we collaborate. We're a multidisciplinary company. We like to, consider ourselves as a one-stop shop so that we can work, help the families however way we can, and they're not having to drive all over town to get the services that they need. We do accept almost all private insurances, and our sister company also takes Medicaid. Reliant ABA also started taking Medicaid, so we do have a lot of kiddos that are with us now with Medicaid, and we also offer private pay if needed.
Miriam, thanks for sharing that. And that is a big deal because a lot of places don't go to age 18. And so I know that a lot of the families that we serve, they still have needs. And I had the pleasure of touring your facility in Katy, which was awesome. So I do suggest other people do the same, just because we do have people that attend this from all over. Do you guys have other sister locations across the state of Texas? Do you have other sister locations outside of the state, Reliant as a parent company?
So as of right now, we do not, but our sister company does offer in-home throughout the city of Houston.
Okay, perfect. Thank you so much for being with us.
Oh, no problem. Sorry. We are going to be opening a second Reliant ABA in Cypress. We're hoping next year.
Perfect. And yes, the recording of this webinar is going to be made available to everyone. And as an added bonus, everybody is going to get a copy of today's slides in a PDF by email. So thanks for asking that. Christina, we are so glad that you're here with us here today. You're going to be talking about our top 5 special needs documents. Christina is a powerhouse. She is awesome. She is very, very well versed when it comes to special needs and special needs planning. A lot of times there's confusion on what we do, what does Consolidated Planning Group do, and what does the attorney do. So Christina gets calls and says, I need to open an ABLE account. We get calls saying, hey, I need guardianship and I need to open up a special needs trust. And so I say they're the legal documents. You have to have the attorney. We're the money. Okay, we're the money in the right buckets. We work together, but neither one of us do the same thing. And so a lot of people put us all in one bucket, and I always just like to clarify that. So Christina, tell us a little bit about yourself and your firm, and thanks for being with us today.
It's good to see you again, Allison. So this is my 20th year of practicing law. Pretty excited about that, and 19th year of my law firm. So I have a degree in social work and was a social worker for a special needs disability elder law attorney in Austin, and then moved to Houston where I opened up my practice in 2004. And this area of law is very personal and special to me. I have a medically fragile nephew that's about the same age as my youngest son. So a lot of these estate planning documents I'm going to talk about today with everyone, I've also talked to my sister and my family about. We've talked about things like beneficiary designations, which we're going to talk about. We've talked about who's going to be the guardian of our children if something happens. So this area is very, very special and very personal to me, and we take it very seriously. We too have a very interdisciplinary approach to our services. We work with other team members like Consolidated Planning. Very excited to learn about all the good things that Miriam is doing over at her work at her office. And it really takes a village to put together a good plan. So that's just a little bit of our practice philosophy. We have a geriatric and care manager for people with disabilities on staff as well. So yeah, that's a little bit about me and our practice.
Thank you. I'm getting crazy over here with the slides. So yes, but do tell us what a care manager means, because I'm not sure everybody even knows what a care manager means. And I do know that a lot of law firms don't have a care manager. So what value does that bring to the table if they're working with your office?
So a care manager typically first is somebody that has a professional degree in social work, psychology, nursing, and their role in our office is to implement the services that we're able to provide for our clients. So for example, if you have a child that's on a Medicaid waiver program and you're wanting to get home services, our care manager, whose name is Robert, will look at your budget that you have from your Medicaid managed care organization, and we'll look at how we're going to actually get people to the house and who needs to come to the house and when they're going to come to the house. And also if there's an issue, he'll help to problem solve with the family members. He and I will also come up with things like how much money a trust needs to have at funding. And if we have someone in a nursing facility or has an issue at a hospital, he'll problem solve if we're having some issues there as well.
Awesome. Thank you for that.
So Allison, do you want me to get started on the top 5 slides there?
Yes, that sounds perfect.
Okay, so everyone here on this webinar today has somebody that they love in their life that is a person with a disability or some type of special need or some type of issue. One of the things I want every person to think about are these documents that we have listed here are things that every single person over the age of 18 needs to have, whether you have children or not, whether you have a child with a disability or not. We're going to talk about documents that are geared for people with disabilities, but we're going to start with just a will or revocable trust. So what does this do? A will or revocable trust takes the assets that you own and gives them to the people or to the entities that you choose at your death. The revocable trust has a little added bonus of it's being created during your lifetime and can help manage the assets, the house, the bank accounts that you own if you become incapacitated. We're going to talk about a third-party supplemental needs trust, which is a trust that's established and funded with another person's money. We're going to talk about a first-party supplemental needs trust, which is funded with that individual who's on Medicaid, their own money. And then we're going to talk about documents for incapacity, both for you, maybe for the individual you love or are caring for. So my clients like to spend a lot of time talking about death planning, what's going to happen when I die. And I know that is a natural, normal focus, but we also want to think about what happens if the parents or the caregivers, one or both becomes incapacitated. Do we have the right instruments in place so that you can have your assets managed by somebody you trust? That's going to be true for your finances, your medical. You're going to want to give a group of people access to your medical information. If you have children, maybe you need a declaration of guardian for them or maybe for you. I have minor children, so I have an appointment for health care for my minor kids. And if my husband and I are out on vacation somewhere and, you know, my oldest Luke has a cut on his leg, then I've got family appointed to make emergency medical calls if I can't be reached. And then we also have to talk about end of life decision making for everybody. So documents for incapacity, documents for death, and then Allison, this is our hot button is up next, which is the beneficiary designations. I can tell you, Allison and I spend a lot of time thinking about beneficiary designations. So here's the takeaway, folks. When you die, the law is going to separate things that are going to pass by your will or your trust, or things that will pass by beneficiary designation. A beneficiary designation will control or trump over any legal instrument that you have. So just doing your will is not enough. Just doing your trust is not going to be enough. What you have to do is look at every single asset you own and see, if I become incapacitated, is this asset in a trust so someone can manage it, or is it a financial power of attorney? And then where does this asset go when I die? That's that beneficiary designation. And by the way, you need to check all of this information on a fairly regular basis. Make sure it says what you want it to say. Okay, I think I'm ready for the next slide.
Yeah, Christina, I think that the checking back on a fairly regular basis is important, because people die, people fall out of love, people get divorced, things happen, and they don't update their beneficiaries. And you said something that is super key, and I just want to reiterate it, that, you know, I hear all the time, oh yeah, that's all taken care of in my will, except your beneficiary designations on any financial accounts, life insurance, investments, annuities, pensions, 401ks, 403bs.
Yes.
The beneficiary designation is going to trump anything in your will or trust. And so it's very, very important that people did hear that. So the big thing on the beneficiaries, and I apologize in advance if you've listened to us before and I'm a broken record, but I always will be on this topic because it's such a hot button and it's such an issue. What a lot of people do for beneficiaries, they say, okay, if I die, my spouse is going to be the beneficiary. And if I die and my spouse is already dead and gone, then that's easy. I'm going to divide it equally amongst my children, and they name their children. Okay.
Yes.
So there's a couple of issues with that. The first issue is if you have minor children, I take issue with naming minor children as beneficiaries because basically when you do that, what happens if you die while the child is a minor, the money sits in trust until they turn 18, and then they turn the 18-year-old loose with a lot of money. And it's usually a bad idea, even though your kids are geniuses just like mine. It's not a good idea to get large sums of money for an 18-year-old. So there's more effective ways to doing that. So the other issue with naming a child or an individual outright, we don't ever want to name an individual outright who has a disability. Okay. And the reason for that, I know you've probably heard that before, is we don't name our kids as beneficiaries, but why? Why don't we do this? And the whole premise behind not naming a child outright as a beneficiary is because we never want an individual with a disability to have more than $2,000 in their name, because that is the Medicaid guidelines. If they have more than $2,000 in their name, they don't qualify for Medicaid. All of the waivers in the state of Texas, well, in most states, they're called Medicaid waivers, which require Medicaid eligibility. So there is a right way, because as parents, we do want to plan for these kids. We do want to make sure that there's sufficient funds for their future care, but that's where we're going to be funding their future care with a special needs trust, as opposed to naming them outright. And then Christina's going to talk more, but the trust is going to distribute money in a way that is going to keep them eligible for their benefits. So we just definitely want to mention that.
And one thing I just want to add is I never want to, and this is one of my huge pet peeves, it's even bigger than a pet peeve, is a person with a disability not being named at all in any estate plans because they're afraid of going over that $2,000 countable asset mark. So don't be afraid to make provisions for your child who is on or may need Medicaid. You just have to do it the right way. And naming their sister as the beneficiary, hoping that she will take care of it, is not a good way to do it. She could get divorced. She could use the money for herself. There's lots of bad things that could happen. So there's a better way to do it, and we're going to show you how.
For sure. Thank you.
All right. So here's a big question, which is, do I need a will or a trust? What suits me? What's the best? So my personal preference when I'm dealing with families, and this has changed a little bit over the years, is if you have a child with a special need or is on Medicaid, I will typically recommend a revocable trust. And a revocable trust is just like a legal instrument that is established during your lifetime, and you carefully can fund it. And then at your death, a supplemental needs trust can be created for that child who's on Medicaid. And then any assets in the supplemental needs trust can be used by the child that's on Medicaid, but it's not counted when determining financial eligibility. So I come from a long line of school teachers, so I'm going to give you a visual representation of what a trust looks like. I'm also a big Judge Judy fan. So if you know me, you know I love Judy. This is my absolute favorite mug, and it says only Judy can judge me. So this is our revocable trust. In this trust, it can be a supplemental needs trust for a child with a disability who's on Medicaid or may qualify for Medicaid. And during your lifetime, you're taking your assets, which are represented by my highlighter here, into the revocable trust. It's for your benefit, your partner's benefit, your spouse's benefit. And then when you die, you can direct that this asset goes to the supplemental needs trust. And the supplemental needs trust will be handled by a trustee. All of this takes place without having to go to court. It's done by a trusted individual or individuals, or maybe a corporate fiduciary, or maybe a master pool trust gets involved, but it's outside of the scope of a probate court. If we have a will, then the will has to go through probate, which takes time. There's some administrative pleadings that all takes time. If I have a child or an adult with a special need, especially in a situation where the parents have been providing financial assistance, I don't want to have to make that child wait till the probate process is done in order to have access to cash for them. So that's why I like to use this revocable trust process rather than having to go through a will. Even if you have a revocable trust, you still have to have a will in case for some reason you have an asset that didn't make it to your trust. We do something that's called a pour over will, and it does exactly what it's titled as, is it pours that asset that you maybe inherited or owned and never got it to the trust. It pours it directly into the revocable trust, and it minimizes any kind of probate proceedings that need to happen. But typically, I recommend a trust, but you can have a well-drafted will with a supplemental needs trust in there for your child or the person you're concerned about. Just know that that will take 6 months to process, and you need to think about how your child's going to pay for his or her expenses during that time period.
So Christina, is this also called like testamentary or something? Or tell me, what's the name of this? Like, so you have like a will.
Yeah.
And so I want to clarify this because there is confusion on this that I hear all the time. So what she's saying, I'm summarizing, you can correct me, is you can have a will that basically has language that the trust, the special needs trust, will be established upon your death. And what I think you're saying is, yes, you can do that. And it's cheaper to do that on the front end.
Yes.
However, on the back end, it's going to take a lot longer to get that trust set up, and there could be delays in getting the money to your loved one. But the other thing that I want to mention here that's super, super important, a lot of families have affluent family members, grandparents, parents, other people that could possibly leave money to your special needs child. And if that is the case, what we just described of having a will that says that the trust will be created upon your death, it doesn't get created on grandma's death, right? So there is no trust.
That's a great point. Yes.
So I just wanted to mention that, because I will tell you too, the thing is so getting started, if that's what you can afford, there's no shame in that, and kind of upgrading later down the road is totally good. But when someone dies, there's a lot of moving parts. There's funeral, there's cleaning out of a house. There's so many moving parts, and already having that trust already set up, it makes things a little less bumpy. So it is my suggestion, that is a consideration when you're kind of deciding how to set that up.
And that's something that is not going to be different from client to client. So my morning appointment, maybe they're a busy couple, they have young kids, and I know from having small children, they're just trying to make it. So maybe I just do a will for them. And then maybe as things change and things settle down a little bit, maybe then we'll talk about trust planning. Because with a revocable trust, there's work involved on the client's part and my part to appropriately label things in the name of the trust, and it takes time. So kind of my rule of thumb is if you're a young couple, we might look at a will first, but if I've got, someone that really is good at paperwork and is willing to work with us, even if it takes a little while, we'll usually lean on that revocable trust.
Perfect. Oh, geez. Getting crazy with my mouse here. Okay.
Okay, so we talked about
someone says,
okay.
In the context of having funds available for someone with special needs, at some point in this conversation, can someone please explain the difference, pros and cons of the revocable versus irrevocable trusts?
So typically what we'll suggest is a revocable trust for a parent during their lifetime, and then it will become irrevocable when they die. Supplemental needs trusts that are set up by third parties, meaning that's not established by that Medicaid beneficiary's own funds, those can be revocable or irrevocable. I tend to make them irrevocable, and I'll add something that's called trust protector language that will allow us to make changes. But I like the revocable trust for the parents because I think if you can change it and you have more flexibility. I think if maybe you're concerned about creditor issues, you may want an irrevocable trust. But I do not see that fact pattern in my office very often.
One other question before we move on to the next slide. One question that comes up quite a bit is, can there be more than one special needs trust? Because sometimes there is a divorce situation and the one parent doesn't want the other parent to control it, but they both want to provide for the kids. So can you talk about that?
Sure. So especially in a divorce context, there probably should be two separate supplemental needs trusts for the primary fact that the people that each parent wants to be in charge of the kids' money may be different. And then the other is what we call the remainder beneficiaries, meaning if that child dies, where does this money go? And probably the two spouses or the ex-spouses will want different places. So yeah, I typically recommend two different trusts for that. That works initially at the drafting phase and maybe even the funding phase. But then we've had issues where we've got a child with two different trusts, figuring out what trust is going to pay for what. So hopefully there's some coordination that can be done between the parents. So, okay, why do we need supplemental needs trusts? As Allison mentioned, most of the Medicaid programs, which by the way, there are 109 Medicaid programs and they all do different things, which is why it's incredibly confusing for families and practitioners such as myself to be able to guide our clients and our loved ones through. Each Medicaid program has their own income requirements, their asset requirements, transfer policies, meaning some of them say you can give away money, some of them say you can't. In fact, most of them say you can't give away money, and they have different disability or medical requirements. So when people say we're on Medicaid, it's kind of like saying you have a cold. Well, it's every Medicaid program has specific requirements. So typically, Medicaid is going to divide the assets that an individual owns into two categories. One is going to be countable, and the other one is going to be exempt. Countable assets, there's some examples, is not an exhaustive list. It's a cash, bank account, second car, second home. Exempt are going to be things like a homestead, personal items, a car of any value, clothing. Most Medicaid programs will cap the countable assets for that beneficiary at $2,000. Yes, there are 109 Medicaid programs in the state of Texas. I think I saw some comment about that. That is yes. And the reason why I know that is I do this big Medicaid update for the UT School of Law, and my co-author counts them every December. So and I think it will sometimes fluctuate between 107 and 109, depending on how they're shifting things around at the Medicaid program.
And I just want to mention on that you don't have to be well-versed in 109 Medicaid programs. Medicaid does come along with SSI, but when you go to yourtexasbenefits.com and you create a username and password, and then you fill in all of the information that they ask, it will spit out what programs your loved one is eligible for. So you don't have to educate yourself on all 109 programs. It is a little bit overwhelming, but I think that the main thing that you guys need to know on Medicaid again is you can have $2,000. You can have one house, you can have one car, and there's some ifs and buts on the second car, like if there's a big loan on it, or if it's 20 years old, or if you would actually sell the car to provide final expenses. So there's some little caveats, but for the most part, the best thing you should think of is one house, one car, and no more than $2,000 assets in their name. And for our kids that are, you guys are getting close to transitioning, maybe they haven't qualified for SSI all these years because you make too much money. Everything changes whenever they turn 18. It's based off of their income and assets, not yours. And what I want you to be careful of and to think about, sometimes grandma and grandpa started buying savings bonds when your kids were born and you forgot about them. So they can add up. So it counts everything. It's not just the bad bank account. It counts everything. If you have more than $2,000 in your child's name, what do we do? The first question is, can we hide the money? The answer is no. You can't hide the money, but there are
Yeah, that's
legitimate
correct.
things that you can
Yes.
do to move the money into what we call the right buckets to be under that $2,000 limit. And so one place that you can put it is into an ABLE account. That's under the tax code 529A. We have entire presentations on that. We're not going to go down that rabbit hole right now. And the other place that you can have their money is in a first party special needs trust. So those are two places, if we have more money than the $2,000, that the money can be redirected to that will maintain their eligibility. So we always just want to mention that.
And then they can do things like if you have more than $2,000, you can always do what we call spend down, which is a preneed funeral contract, maybe an iPad, maybe there's some other things that they need. But the benefit to these supplemental needs trust is that, especially if it's a third party trust, meaning it's money from a parent, grandparent, it protects these assets to be for that person, that beneficiary, that child, and from the creditors of who's in charge of the money. I don't always trust people to do the right thing. They may die, they may get divorced, they may be sued. So that's why these third-party trusts are so important, rather than giving the money to a family member that's trusted to hold. Now, maybe that family member could be a trustee, but if that family member is given the money and then he or she dies, it's part of their estate, and then your child doesn't have access to that money anymore.
It's a big mess. There's two questions. One is, what if our adult child is now under our guardianship? Once the child is over 18, even if they are under a full guardianship, it's based off of the individual's assets, not the parents. If anybody tells you anything else, that's wrong. It is based off of the individual's assets once they're over 18, regardless of the guardianship status. And then the other person's question was, if there are two trusts, like the grandparents established a special needs trust and the parents have a special needs trust, is there one in particular that's primary? Is there even a such thing as primary language?
I think you could add, that would be up to the drafting lawyer. I mean, you could add language that would say that, you know, the trustee shall take into consideration any other trust first before making distributions. Ideally, you have a copy of both trusts and you look at the distribution language to see when and how and what things the trustee is supposed to look at before making distributions. But as far as like a first in time being the primary trust, no, nothing of that.
One thing I want to say that is super, super important, as I was mentioning earlier, that the, you know, just as not very many financial advisors are nuanced in special needs, there's not a lot of, there's a lot of elder law attorneys out there, but they're very specialized in special needs, and that's what you need. You don't want your attorney next door drafting your documents as a real estate attorney. You want to work with a specialist as it relates to your documents. And the other thing I want to mention to you is grandma and grandpa, mom and dad, their attorney is probably not nuanced in special needs, is what I have found. And so when mom and dad or grandma and grandpa tell you that they have a trust, what we've seen is many, many times, the trust is not a special needs trust at all. It's just a regular trust, a different kind of trust. And it truly does have to be a special needs trust for it not to be counted against them. Just saying it's a trust doesn't work with the Social Security Administration. If it is not a special needs trust, it's going to be counted. So I think it's really important to get the details or ask or get your attorney involved with their attorney to make sure it's legit. Don't find out at death that it was wrong.
And the other thing we see is attorneys putting in language, oh, I can throw a supplemental needs trust, but the lawyer has no idea about any of these Medicaid programs. So they have no idea how to take the money out of the trust in a way that's meaningful for that beneficiary. So I think we had just one question I saw. We'll just kind of, oh my goodness.
Yeah, it's coming up. So let's talk about, this is where we go to the OOPS trust. If grandparents refuse to change their trust, is it possible to change it once they pass away? Tell them what happens if grandma and grandpa leave money to their special needs child directly.
Okay, so let's say it's in a trust. Well, as a practitioner, what I'm going to do is I'm going to look at that trust and see if there's any way I can fix the trust. Okay. And that's called a trust modification. I would prefer to do a trust modification because I might not have to send that assets to what we call a first party trust. And the reason why we don't want to send assets to a first party trust is because when the child dies, when the Medicaid beneficiary dies, there's a payment back to the state or states that that child had Medicaid benefits from. So the state has to get reimbursed first. So I will, and we do this fairly common. So I get a grandparent's trust. The grandparent said, I set up this trust. I don't want to change it. I'm happy with it. Grandma and grandpa dies. Now that child has this trust. We do have to report that to Social Security, but we will go in typically at the district court level and try to do a modification so that that child does not lose Medicaid eligibility.
Great. So which trusts, special needs trust, either first party or third party, need to be reported to the Social Security Administration?
Every trust, any trust that a individual is a benefit of needs to be reported. Even if it's, we have these generation skipping trust where the child may have a right to income in the trustee's sole discretion. But we will always disclose to Social Security and Medicaid every trust the beneficiary has an active ownership interest in.
Perfect. Okay, one more question and then we're going to keep moving. What does the special needs trust pay for? In our case, there are not siblings. My son has, after we pass, also not really anyone I want to trust on either end of the family to be a trustee.
Wow.
What other options are available? Because I was told that if we leave it to be handled by an attorney, there's a 1% fee based on the value you have sitting in the special needs trust. I'm still trying to navigate the best options. So I will say that there is professional management through attorneys. There's also professional trust banks that have special needs department that manage trust, but there are going to be fees and they're going to be similar across the board when it relates to trust management. But even if you had a family member with a trust, I mean, isn't there even laws that provide for compensation for trustees in the state?
There's ways that you can determine reasonable compensation, but here's the thing about any trustee. In a special needs situation or just any estate planning context, they have to meet the 3 T's. They have to have talent, they have to be trustworthy, and they have to have the time to do it. And so usually I'll get 2 of those 3, meaning they're very bright, they're trustworthy, but they just don't have time. I would be a terrible trustee. I run a law practice. I have 2 kids. Nah, you don't want me as your trustee. So I would suggest that families look at a variety of ways that they can bring people in that they trust if they have a corporate fiduciary. And that role, I don't think we have this on a slide, I can't remember, Allison, it's called a trust protector. And so what a trust protector does is if somebody if there's a bank or some professional trustee involved, and that trust protector, usually a family member that doesn't have the time element, but is very trustworthy and loves that kid and understands what that kid needs, then that trust protector can remove that corporate fiduciary. I would also encourage family members, if they're concerned about fees, to think about, you know what, it does cost money to manage money, but you're going to pay somebody. You're just not going to get out of it. And the benefit to having a corporate trustee is if they do something wrong, they have deep pockets and they can be sued. Individual family members, you know, unless it's a very unusual situation, when they mismanage funds, it's usually very, very hard to have that beneficiary, that disabled individual, be made whole again or get their money back. Yeah.
For sure. So someone says, is there a downside to planning on an ABLE account funds being used to cover expenses during probate versus having a revocable trust? I would say there's several downsides of what I would say. First and foremost, I get questions all the time of, can I leave the beneficiary an ABLE account? Can I make a beneficiary an ABLE account? No, you cannot. So we cannot make the beneficiary on our life insurance policies an ABLE account. An ABLE account, if you Google it, they're going to tell you that you can have $500,000 in an ABLE account, which is true as long as you don't care if you lose Medicaid and SSI. So if you care about Medicaid and SSI, if you care about Medicaid waivers, you never ever want more than $100,000 in an ABLE account. You can only put $17,000 a year into an ABLE account, an additional $13,590 if the individual with a disability is working. So what I would venture to say is there's never ever going to be enough money in an ABLE account to cover everything that needs to be covered. So some people,
and
I think,
you have the payback provision too on the ABLE account.
correct. So there's a Medicaid payback on that. There's no Medicaid payback on that third-party special needs trust. And the lady earlier asked, what can we pay for out of a special needs trust? And it's very broad what you can pay for out of a special needs trust. It's also very broad what you can pay for out of an ABLE account. So basically, if it can be construed as achieving a better life for an individual with a disability, you can pay for it out of an ABLE account. But the key thing, because we hear this all the time, why should I have a special needs trust and an ABLE account? I don't get it if they can pay for the same things. A special needs trust can truly pay for food and shelter, but there will be a 1/3 reduction to your SSI if you do that. You can pay for food and shelter out of an ABLE account without a 1/3 reduction to SSI. So that is a key reason. Christina, do you have any thoughts on that, or talk to us about that?
I was also looking at, just kind of going back to the comment, is just looking to cover through a probate period. I think it's a bit of a risk, because if you put money in an ABLE account and that child dies before you, then you would lose that money. So when we're thinking about taking money out of a trust, it's so individualized. And that's why a knowledge of what each Medicaid program provides is important. Sometimes it really is worth giving up 1/3 of the SSI to have food and shelter be taken out of a supplemental needs trust. I guess, it's a very lawyerly answer. I'm sorry. It depends. It depends on what your child is. I just would not put funds in an ABLE account to get through the probate period. I wouldn't do that. I would put it into a supplemental needs trust.
I like the ABLE account for a lot of reasons, and it grows tax-free, and there's tax-free distributions, but you're right, there is a Medicaid payback. And what we teach people is how to play the game with the ABLE account, how to put the money in and take the money out and get the money out for the benefit of said child. It's not our goal to have, gobs of money in that ABLE account. We're going to get to a few more questions in a few minutes. We're going to continue with the third-party special needs trust for now.
All right. Okay. So these third-party supplemental needs trusts, they can be established by anybody. The person that sets up that trust, called the grantor, or the settlor, can be anybody. So I always use my family as an example. I have a will, and I have a trust set up for my nephew, and he has money that's going into this trust. And I know that if he dies before the trust is depleted, then that money that's left over goes back to his cousins, my children, and I can name backup beneficiaries. And I also know that these third-party trusts are reviewed with a lot less scrutiny than these first-party trusts. And just to refresh everybody's memory, the first-party trusts are those trusts that are funded with assets that belong to the Medicaid beneficiary. The way Social Security and Medicaid looks at it is, if you have too much money in your name and you're under 65, you can put your overage into this first-party trust. And as long as it says that when you die, we get repaid to whatever we've sent out or paid for you on your behalf, they look at it like a loan. And so these first-party trusts are reviewed with a tremendous amount of scrutiny. Every February, I go to a conference in Austin, and we meet with the Trust Review Board for the Social Security system, and they will go through all the things they don't want us to have in the trust. So they have a checklist. These third-party trusts, not so much. So they're really looking at when a Medicaid beneficiary has too much money in their name, those funds are transferred to a trust to maintain that Medicaid beneficiary's eligibility for benefits. They really want to take a look at that. So third-party trust, if you have money and we're able to direct it the right way, this is the way you want to go. Okay. Allison, anything before we move over to the next slide?
Nope, I think we're in a good spot.
Okay, so we talked about these first-party trusts. Now, these first-party trusts, I in my practice, I call them oops trusts, meaning, oops, something has happened. Oops, grandma left you those savings bonds. That's such a great example, by the way, Allison. I think everybody's grandma got them a savings bond. Or somebody named, I have a case right now where a gentleman was named in an individual capacity on an IRA. Now we have to do something. We have to set up a first party supplemental needs trust. Remember, we just talked about these are viewed with very, very fine detail by the Social Security Trust Review Board. And these are the requirements, or some of the requirements, that Social Security and Medicaid has. So the person that's established the trust, that's a grantor or settlor, that has to be a parent, grandparent, guardian, or court order, or under the S&T Fairness Act. The beneficiary they are able to be their own grantor. Back in the old days, before the Supplemental Needs Trust Fairness Act, we used to have to go to get a court order, even if the person had capacity. Now that has been fixed. So a couple of other things. The trustee can be any person or entity other than that individual who is the beneficiary. So, and that's true for third-party trusts as well. As a beneficiary, you could never be in charge of your own money. If you are the trustee, then that trust becomes a countable asset and the individual will lose eligibility. The money that goes into the trust are typically, most of it is beneficiary funds from that disabled individual. So in my case, it's a gentleman who was named as a beneficiary in an individual capacity for an IRA. And so he is going to be using his money to establish this trust. And we have to make sure that when the trust is funded, that the individual is under the age of 65. And anything that's taken out of the trust has to be what we call for that beneficiary's sole benefit, meaning no one else can benefit or enjoy those distributions that are taken out other than the person that's named as the beneficiary. Third-party trusts don't have that requirement, but first-party trusts definitely do. And then, of course, as we've talked about today, after the death of the beneficiary, to the extent that state or states paid any money or services for that individual, they has to go to be repaid to repay Medicaid first. You can name a backup beneficiary. We see these first-party trusts also in the context of a divorce case where maybe child support is causing the individual to have too much income to qualify for SSI. You can run that child support payments through these first-party trusts for that child support not to be counted and the child to remain eligible for Medicaid and Social Security benefits. All of that, by the way, requires lots of lawyers and court orders, so it does not happen overnight.
But it's important, and we said that very quickly. So a lot of times, and I know we have other people from other states on here too, but a lot of times in Texas, not always, that child support, if you are in a divorce situation, the child support continues post age 18 for your loved one with a disability. And so I just want to reiterate this because this becomes a big debacle. You really do need to get that child support under court order moved to a first party special needs trust, which means you have to set up a first party special needs trust in order to do that, because if you don't, it's definitely going to be counted against them as income for SSI purposes, and it may cause them to not qualify at all, or it definitely would cause their SSI to be reduced. So it is really, really important. It doesn't have to be hairy and adversarial. If both parties agree it's the same amount of money and we're just redirecting it, I mean, it's a matter of getting an attorney to write that up and get that handled. But it's really, really important. And I would just advise, you know, again, we can help you and we give tips all the time on applying for SSI. Don't apply for SSI until you have this taken care of, because it is going to be a train wreck. So call us, call Christina, call somebody. If that is your situation, you do need help with that. So be planning on that.
Absolutely. Absolutely. So we're going now into documents needed for you and your child at incapacity. Everybody who is over the age of 18, even if you've been married a very, very long time, you need a financial power of attorney. If you take nothing away from our talk today, I'm hoping everybody on this webinar has a financial power of attorney, because if you don't have a power of attorney, I mean, you as mom, dad, caregiver, and you become incapacitated, even if you've been married for many, many years, you will have to go through guardianship, which is an expensive and time-consuming process to manage your own financial affairs. And then the focus is taken off your child, the health and well-being of your family, and on this unnecessary court procedure. Likewise, you're going to want a medical power of attorney, HIPAA release, directive to physicians, appointment of guardian, maybe for you and your child. And we talked a little bit about a healthcare agent for minor child. One of the things I want to recommend is if you do have a financial power of attorney already in place, good for you. This is what I want you to do next. Send it to the financial institutions for pre-approval, especially IRAs. Just because your spouse is named as a beneficiary on your IRA, that does not mean that he or she will be able to manage it during your lifetime. And usually when you have to manage another person's IRA, and the person's still alive, typically there's been some type of spell of illness or disability. You want things to be as smooth as possible. So it's a good idea to go ahead and get that financial power of attorney that you have to the financial institution for their pre-approval. And I just have one other little note before Allison's going to come in is if you have any kind of specific funeral arrangements that you want for yourself, please go ahead and do that. Do you want cremation? Do you want a traditional burial? Do you want to donate your body for study or an organ donation? Please make these choices easier for your family so they don't have to search around and try to think about what you would have wanted done. Make as many of these tough decisions in writing so that they have instruction so that they can continue to focus on caring for your child that has a disability.
So this is so true, and we see people in crisis that they didn't have these documents in place. And the only thing I would add here is as you're thinking about this for yourself and your spouse, make sure that you have intentional conversations with any aging loved ones in your life, parents and grandparents and things like that. It's possible they don't have these documents at all, or that their documents haven't been updated in 15 years. There's all of those things are possibilities. And I'm a mom who is a fan of having a power of attorney and healthcare power of attorney and HIPAA release for our college-age children that are going off to college.
Yes.
But you never know. There could be a car accident. There could be a mental health crisis. Anything can happen. Let me just tell you, if there's a mental health crisis and they haul your kid out somewhere, they won't even tell you where they took them.
Yeah.
It'd be like a needle in the haystack, if you're in Houston or San Antonio or Austin, wherever, trying to figure it out. So I think, and, you can have them to where they take effect in the event of incapacity, or they could be immediately effective, but whatever. I just suggest that you should have it on your young adult kids as well, just
absolutely.
in case.
100%. All right, let's go to the next slide. Okay, so here's my big hot topic of the day, which is guardianship. I get a lot of questions in my office about guardianship, about do I do it 6 months before they turn 18? No, you can't do guardianship typically until just before the kiddo turns 18 because you are the natural guardian before age 18. And then we have to look at what is the court going to be looking for. And by the way, it's a legal process. It's a lawsuit, meaning a petition has to be filed. We have to have a doctor's letter, medical evidence showing that your child doesn't have capacity, doesn't have the ability to handle their financial or medical affairs. And then we also have to show the court that we've looked for every other alternative for this child, including powers of attorney, maybe supportive decision-making, maybe some type of services that could come into the home to avoid guardianship. There definitely is a spirit, and the state code encompasses this thought and policy of having people live in the least restrictive alternative possible. Because when you're under a guardianship, your rights can be taken away to vote, marry, choose where you want to live. Some of that can be built back in for the person. Some cases, it's very clear to me that this individual needs a guardianship. Sometimes I think, well, we need some more medical information before we make a decision. Or sometimes I'm thinking, we just need powers of attorney for this person. By the way, just because you don't get a guardianship at age 18 doesn't mean you can't get guardianship later on. I recently did guardianship for a mother and her son. I believe the son is at least 50 years old and the mother is about 80. And he is an individual with a disability. He, for most of his life, was working and doing well. And As he got older, he started to have some additional health issues, some cognitive issues. And the judge asked us, why did you wait till he was, 50? And the mother honestly replied, he didn't need it when he was younger because he was able to make decisions for himself. So that's one of the things I want you to think about. It's very individual for you and your family. What I don't want you to think is that once we get guardianship, then it's easy just to get rid of. That's not the case. Once you're in guardianship, we have to show the court that something has happened. The person who's under guardianship has recovered. They've had some type of medical intervention. Maybe they had a brain injury and that got better, so they don't need to be under a guardianship, and they can be what we call restored. But that is very few and far between. So in other words, don't look at guardianship to solve problems. I had a family years ago who used guardianship to get their daughter out of a lease. Then I had to be the bearer of bad news and say, sorry, the guardianship continues even though that problem has gone away.
So two things. The one thing that I want to say too is that it can go the other way too. There are individuals with disabilities that definitively do need a guardianship.
Absolutely.
And we've seen where parents had a power of attorney or healthcare power of attorney signed by an individual that didn't have capacity. And we've seen that rendered no good
Right.
in a time of crisis. So I think it is what I tell people, you don't have to know the answer. Okay. You just have to know and meet with a professional that is nuanced in special needs and guardianship, and they're going to walk you through the process, walk you through. They're going to talk through your options, and together you guys are going to come up with that. So you don't have to have all the answers. And then the very last thing that I had on this one before we move on, we got about 5 minutes left. We had always heard that, no, you can't get guardianship 6 months before they turn 18, but you can begin the process so that way that it can be done, real close to their 18th birthday, like, soon after they're turning 18. Is that true, or dispel that myth, please?
So if no, you can't get it before their 18th birthday, but what I'll do is I'll get the doctor's letter, I'll get everything lined up. And I've got a case right now that the young lady is turning 18, like in July, I think. And so her birthday's on a Sunday, and that Monday, we're going to file the application for guardianship of the person.
So the point is calling the attorney a little bit ahead. You can't get the guardianship before they turn 18, but getting started with the attorney a little bit ahead, so that way those documents can be in place so we can pull the trigger once they turn 18 is key. I know, I think we did a big rabbit hole on the beneficiary designation. So is there anything on here that you want to hit on?
I would just check those beneficiary designations regularly and provide that information of where your accounts are to the people that you're going to be wanting to help you. So, yeah.
And don't forget old pension plans, old 401ks, or anything like that.
Correct. Yes.
Okay. So we have a question I'm going to put out there. We had a person that consulted an attorney about how to petition the court to be the guardian of the estate for a sister. And so they had applied for the sister to receive a portion of dad's retirement and annuity. And then they were informed it would be considered income, and the amount of the annuity payment minus the SSI she receives must be at least $1 to maintain Medicaid. The annuity was slightly over. And so she had to resend the application for her to receive the annuity. I told her that this might be kind of a one-off. It sounds kind of a little bit complicated because I know that there was a new legislation for military pensions that can be moved to a first-party special needs trust. So I think there's a lot of details that we're probably missing.
And by the way, there's been new policy that will allow a two-step transfer. So if an individual is a beneficiary on the IRA, we can now move it to a first-party trust without breaking the IRA. So if there's that may be an option for that family too. So, okay.
Could you hit on the quickly? Can you hit on the problems that can occur if the money goes directly to the child or even the trust. I know we touched on that, but I want you to just revisit. So someone said that, they would resent somebody telling them to change the terms of their will. So can we hit on the highlights again of if we leave money directly to an individual with a disability, the problems that occur with that?
Okay, so someone says, I would resent or I resent someone telling me to change the terms of my will. So I'm not quite sure if I understand, Allison, the
I think they're
Can you help me
basically
understand
trying to understand why we would tell them not to name their kid directly as a beneficiary. It's a personal decision to name people how you want. And from what I can tell you, is it's a matter of the state and federally funded programs that you want your child to be eligible for. There are multiple Medicaid waivers in all states, and we have a complete webinar on those waivers. Those waivers are not nothing. Some of those waiver budgets are $340,000 a year to defray some of the cost of caring for an individual with a disability to keep them in home and community-based services. When we leave money directly to an individual with a disability, they are over those Medicaid limits of $2,000, which would disqualify them for SSI. It would disqualify for them for Medicaid and any Medicaid waivers and services. So it's not saying that we're not going to leave money to the child or leave money for the benefit of the child. We're going to leave it to a special needs trust that will distribute the money in such a fashion to maintain their eligibility for all of those programs. And your child is still going to benefit from the resources that you left for them, and they'll be distributed accordingly to your wishes that you have set out in that special needs trust.
And so let me just give you an example. So my nephew, his care is probably about $100,000 a month. He is under private health insurance, but he has lots and lots of visits to the doctor, lots of durable medical equipment, lots and lots and lots and lots of stuff that he requires. So we want to make sure that he's not named individually, because if he is and he loses Medicaid eligibility, that's a big problem. That is a huge problem, because even though he's under private health insurance through my sister's employment, that doesn't cover everything that he needs. So you really have to look at what are you giving up if you don't look at some of this planning. And you may be giving up, oh, the kid's not really pulling much from Medicaid right now. But I tell them, that's okay. You don't want your kid to be sick to be pulling it, but it's good to have that Medicaid benefit in place, because when you're not around, the people you're going to entrust to care for your child, they may need that Medicaid benefit, because that child's health care, the healthcare needs may be way more complicated than it was during your lifetime.
A lot of people's health insurance will stop. You can keep health insurance on your disabled child past age 26, but it'll stop at death or retirement. There's health insurance isn't as robust as it used to be. And so those are some of the issues. Now, in fairness to our person in the chat, that we do have clients that have millions upon millions of dollars in their trust, and they simply do not care about Medicaid waivers, or SSI. Yep. And if that's you, then if you want to leave money directly to the individual with a disability, if you know for sure you don't care about that stuff ever, then that there's probably not an issue with that. And I know from a perspective from time, we're a little bit over. You guys have asked wonderful questions today, and Christina and I are both grateful for that. You can contact Christina directly, and we've got her website and her contact phone number, and in the slides we'll have her email address, everything, and set up a consultation. She is available to help you and talk you through on the first party, the third party special needs trust, your conversations on guardianship. Maybe you just need a will. Maybe you have something and you want a second set of eyes, or
we do a lot of
second opinion.
And we're also on TikTok. I mean, I've got young people in my office now. We're not doing dances, but they are pretty funny. So come check us out. We'll have to give you our TikTok handle there, Allison, for our next presentation.
Awesome. Guys, we've got webinars on every single one of these topics, and they're, we could go an hour on every single one, and we do, and they all live on our YouTube channel, the Consolidated Planning Group YouTube channel, so you guys can definitely check it out. In our slides today that you guys are going to get, you're going to get a link for our upcoming webinars that you can register for and, peruse those topics for the step that you're on. We always offer a free consultation, and you can hover over the icon here, and it'll take you to a calendar. We're happy to talk to you about the planning that you've done so far. We're not here to rain on any good planning that you've done, but we do want to make sure that you've got money in the right buckets and that we are properly preparing for the future of your loved one with a disability. Miriam, it has certainly been a pleasure being with you today. Christina, thank you always for your awesome information. Guys, if you guys have additional questions, feel free to reach out. Thanks so much, everyone. Take care.
Have a great day, everybody. Thank you.
Bye-bye.
Bye now.